My name is Tsecho Khailai. Thank you so much for coming back to my Lawyer's Corner. And if you're joining my Lawyer's Corner for the first time, welcome to my Lawyer's Corner. Here at my Lawyer's Corner, we share legal tips, legal nuggets, legal information to help you know a little bit more about your rights as a South African. My core focus mostly is labor law, although I do dabble in some criminal law here and there, some company law from time to time. And so welcome to my Lawyer's Corner. First things first, as a disclaimer, information shared on my Lawyer's Corner is for information purposes only and is not to be taken as legal advice. If you are in a situation that is similar to similar to one where the information I'm sharing could be used in your circumstances, I still maintain that you should consult an attorney and get proper legal assistance. Don't take shortcuts. See an attorney and get proper legal assistance. So without further ado, we're going to get into today's topic. And today's topic is actually something that happens a lot more often than we realize. It happens a lot more often than we realize or we get to know about, and that is constructive dismissal. So what is a constructive dismissal? Constructive dismissal is where an employee resigns from their employment, terminates their contract of employment, either with or without notice, as a result of a continued circumstance or situation that is going on in their employment that has rendered their continued employment difficult or intolerable. The situation must be caused by the employer and must be such that it renders the continued employment of the employee intolerable, difficult, impossible. You just want out, and the employee must resign as a result of that. Now, in the definition of what a constructive dismissal is, we find the actual elements of constructive dismissal, right? There are 3 elements that an employee would need to prove at the CCMA for them to be found that indeed they were constructively dismissed. These 3 elements consist of an act on the part of the employer that renders the continued employment relationship of the continued employment of the employee so difficult that the employee resigns as a result of that conduct. So the act on the part of the employer must be something that the employer has either done or failed to do. Let's make an example. Say, for example, you are being harassed at your employment, either by your line manager, your employer, someone senior to you, someone in your company or in your job environment is harassing you, and you now bring it to the attention of your employer that the situation is carrying on. You bring it to the attention of HR and they fail to do something about it. They fail to address such conduct. That constitutes an act on behalf of the employer, though passive, right? In the inverse, where it's an active act on the part of the employer, you are being harassed by your employer, your actual employer or your line manager. Someone representative of your employer is actively harassing you. Now that is an act on the part of the employer. Second element is that that situation must be so difficult that it renders your continued employment intolerable, difficult. You just cannot, you find it impossible to continue in your employment as a result of the continued harassment. That is when the second element of a constructive dismissal is met. And thirdly, the last element is that you need to be forced to resign. You need to be in a situation where you resign as a result of the continued situation that has rendered your employment intolerable. So you cannot have been planning to resign anyway, or resigning as a result of disciplinary charges being preferred against you. that's not going to help you qualify your situation as a constructive dismissal, right? So if, for example, let's use an example. Jane works at ABC Pty Ltd. Jane's line manager is John, who has been harassing Jane sexually for the last 2 months or 3 months or whatever the case may be. And Jane brings this to the attention of human resources, who have failed to do anything about this continued situation. Jane is so fearful of going to work. She has very bad anxiety every Sunday when she realizes that tomorrow she's going back to the office. She has panic attacks. She is just not handling the situation. She has tried to bring it to the attention of the employer so as to put them in a position to actually do something about John harassing her on a continual basis, and they failed to do so. Left with no option, Jane resigns from her employment. What can Jane do about the situation? Because she feels like she has been treated poorly by her employer and she wasn't actually supposed to resign. She needed her job, but because of the continued difficult situation, Jane was forced to resign. Now, under those circumstances, Jane would need to fill out a Form 711 from the CCMA to refer a dispute to the CCMA, a constructive dismissal dispute. When Jane gets to the CCMA, she will have to prove the presence of those 3 elements that I've just lined out in order to prove that there was indeed a constructive dismissal. What penalty or sanction would ABC Pty Ltd be liable or potentially liable to face should the constructive dismissal be upheld by the CCMA? Now, in Jane's 711 form, she has the opportunity to state there what sanction or what recourse does she want to, in what way does she want to be compensated for the constructive dismissal. Does she want reinstatement? Does she want re-employment? Or does she want compensation? So in a constructive dismissal manner, the employee is able to claim 3 types of compensation, being monetary compensation, being re-employment, and reinstatement. Reinstatement means to be reinstated back into your position as if it never ended, as if your employment has been continued. So your employment was never terminated. You are reinstated with your initial start date and all the benefits that accrued to you since your start date. Re-employment means to be put in any available position that may be available with the employer. It may not be on the same terms and conditions that you were initially employed with. And compensation means you can be awarded a monetary compensation amount, which is normally calculated against the value of your 1 month salary. So you can be compensated up to 12 months salary for a constructive dismissal matter. Sorry, I've got unfair dismissal on my mind because I was dealing with an unfair dismissal matter earlier. So you can be awarded compensation up to 12 months for a constructive dismissal matter. So that is my little bit on constructive dismissal. I hope that this has been some legal information that you maybe needed, or maybe somebody that you know will need it. And remember to subscribe. Tell it somebody that you might know that will need this information to also subscribe to my Lawyer's Corner, where we share legal tips, legal nuggets, legal information to help you understand South African law a little bit better. My name is Tsecho Khailai, and I'm signing out. See you next time on my Lawyer's Corner.